We are VLC. We offer value, providing you with quality review programs and online seminars that bring out the best in you. At VLC, we listen. Adapting to the times, we brought our in-demand on-ground review lectures online with our virtual law companion. Subscribing to this online learning platform means you get 24/7 access to our updated video lectures and bar review notes from the best and most respected lecturers and professors. At VLC, we collaborate, working with the best technology providers through our learning management system to best prepare you for the first ever digitalized bar exams. We work hand in hand with legal experts you can trust, providing top-notch services to those who need it the most through our free online legal consultations and free lecture series. Value, listen, and collaborate. This is the VLC way, and we are VLC.
Only a judge may issue a search warrant or warrant of arrest, nobody else. That is very important. And before a judge may issue a search warrant or warrant of arrest, what are the requirements? First, there may be probable cause. Number 2, to be determined personally by the judge. Number 3, after examination under oath of the complainant and the witnesses may produce. Number 4, particularly describing the place to be searched and the persons or things to be seized or arrested. Those are the requisites before a judge may issue a search warrant or warrant of arrest. But first of all, take note, only a judge may issue a search warrant or warrant of arrest, nobody else. That's why it's still pending on the Supreme Court now, di ba?
Article 3, Paragraph 3 of the Family Code, we have the provision for a marriage ceremony. Now, in our jurisdiction, we do not recognize ceremonial marriages. There must be a marriage ceremony. The minimum requirement is that the contracting parties must personally appear before the solemnizing officer and personally declare that they take each other as husband and wife in the presence of at least 2 witnesses of legal age. Now, even assuming that there was no witness here, the marriage will also remain valid. That will be considered a mere irregularity that will not affect the validity of the marriage. Now, under Article 26, Paragraph 1 of the Family Code, all marriages solemnized
felony within the contemplation of Article 4 of the Revised Penal Code. As a general rule, threat to spank, that is threat, that is a felony. Tinakot mo sasaktan papaluin Pero in this case, the threat to spank is a justified threat to spank due to the circumstance of defense of property. And second, the threat to spank was made in the exercise of a right under the self-help doctrine, Article 429 of the Revised Penal Code. Owner or lawful possessor of a thing has the right to exclude others from the enjoyment or disposal thereof, and for this purpose, he may use force which is reasonably necessary to prevent or repel an act.
Is not allowed to do if you talk about issuance of a warrant of arrest, is to follow blindly the finding of probable cause by the prosecutor, precisely because the prosecutor determines probable cause for the filing of the information in court, whereas the judge determines probable cause for the issuance of warrant of arrest. So makaiba yun. Pero sa issuance ng search warrant, as mentioned, it should be probing. In other words, my friends, the judge must personally conduct an examination of the complainant and the witnesses that he may produce under oath or affirmation. The examination by the judge must be probing. Okay? It is not enough to merely adopt the questions and answers asked by the previous investigator during the PI. Magkaiba yun. Bakit? Kailangan po the judge should personally examine the complainant and the witnesses. So these are the
Good day to our dear attendees from different parts of the country. I pray that you're all in great state of health. This free webinar is streaming live via the VLC Law Center's YouTube channel and Facebook page. If you can hear my voice clearly, please type in the comment section #VLC. Thank you. Yes, thank you. Optimize this learning opportunity. Share this free online lecture to your friends and together learn at the comfort of your homes. I want to formally welcome you all to this free webinar. This is part of a series of free online lectures brought to you by the Virtual Law Companion of VLC Law Center. Allow me to share to you this good news. The Virtual Law Companion is the newest innovation of VLC Law Center, which aims to provide an easy, convenient, and quality bar review experience. The Virtual Law Companion is a web application that is hosted on a dedicated cloud server. It can be accessed via the internet 24/7 for any web browser, using any device or handheld computers like Android or iOS phones. Meaning, you can study anytime, anywhere, and from any mobile device. Please visit our website at www.vlclawcenter.com to know more about our programs and activities. Before we formally start, please take note of some reminders. First, this free webinar is pre-recorded to ensure the uninterrupted streaming of lectures. Secondly, VLC team will be with you to assist you should you need more information about our program. Please visit and subscribe to our YouTube channel and Facebook page. Without further ado, please give your virtual claps and welcome our lecturer today. Again, this free webinar is brought to you by our Virtual Law Companion. Maraming salamat po. Together, we can make things happen. Together, we can.
Our lecturer is presently the presiding judge of MTC Branch 83 in Caloocan City. He began his career in the academe immediately after passing the bar examinations. He was later appointed as Assistant City Prosecutor of Manila in 2002. He gained recognition as a writer and critical thinker in his works and treatises. As a feather in his cap, he was admitted as a professional lecturer at the Philippine Judicial Academy, PhilJA. He is the first MTC judge to be a member of the Department of Criminal Law of PhilJA. He is also the reviewer of choice in criminal law and special penal laws and bar review programs. Ladies and gentlemen, our lecturer for today, Honorable Marlo B. Campanilla.
So, yung lecture ko, this is update sa RA 9165. Ito yung dangerous drugs law. Pero bago ako mag-lecture, mag-advertise muna ako, no. Sa page account, meron akong page account sa Facebook. Ita-type nyo lang Marlo Campanilla. Lalabas na yung page account. Nagpo-post kasi ako doon minsan ng mga updates. So, mas maganda siguro either i-like nyo ko o i-follow nyo ko. No? So, sa Facebook, type nyo lang Marlo Campanilla. Lalabas yung page account ko. So, i-follow nyo ko. At alam niyo naman na may mga libro ako, no? Criminal Law Reviewer, Volume 1, Volume 2, Revised Penal Code, Special Penal Laws, Dangerous Drugs Law, BP 22, and STAPA through issuance of bouncing check,
at saka penal system under RA 10951, no? Ngayon, dito sa Villasis Law Center, meron akong lecture dito na 1 day. So magagaling yung mga professor rito sa Villasis, no? Kompleto yung lecture nila, kompleto lahat ng examination subject, no? Pero sa criminal law, meron akong lecture rito ng 1 day. Pero kung gusto nyo, on top of yung 1 day lecture ko, kung gusto nyo kumpletuhin yung lecture ko, meron akong, sa akin, personal ko po to, lecture na 7 days. At sa July, meron yan eh. After ng July, may mga susunod pa. Pero yung 7 days lecture ko, sa July yon. Ngayon, kung sakasakaling mag-i-enroll kayo rito sa Villasis Law Center at gusto nyo ding, kumbaga kasi yung lecture ko sa Villasis, 1 day lang, kung gusto nyo kumpletuhin yung lecture ko, i-message nyo ako kasi bibigyan ko kayo ng discount. Kasi siyempre, since na nag-enroll na kayo sa Villasis Law Center, mapapakinggan nyo na ako ng 1 day. So kung gusto nyo kumpletuhin, pwede kayo mag-enroll sa akin. Pero i-message nyo ako personal. Bibigyan ko kayo ng, kumbaga, babawasan ko ng yung fee for na 1 day, ibabawas ko yon kasi siyempre mag-o-overlap yun eh, no? At pwedeng hindi nyo napakinggan yung lecture ko yung lecture ko na nilecture ko na sa Villasis, so hindi nyo napakinggan yon. So para hindi na dumoble yung bayad nyo, no? Pero i-message nyo ako para para mabigyan ko kayo ng discount. Basta provided na meron kayong proof na enroll kayo sa Villasis Law Center. Na? So, meron akong ile-lecture regarding the bailability of illegal possession of dangerous drugs under Section 11 B of RA 9165. Pero bago ko ma-lecture yon, magsisimula na, kumbaga, meron muna akong ile-lecture na principle. This is the case of People versus Valdez. Kasi nakakonect yan eh, no? Ang ponento dito is si Justice Peralta, no? People versus Valdez. Ang GR number nito is GR number 21607-09. This December 8, 2015. Na? So, ang ponente dito is Justice Peralta. Kasi ang pinag-uusapan rito, yung Section 13 ng Article 3 of the Constitution. Di ba? Ang nakalagay po doon that all person except those charged by an offense punishable by reclusion perpetua when the evidence of guilt is strong shall be bailable. No? So in other words, under Section 13 of Article 3 of the Constitution, if the offense is punishable by reclusion perpetua, so that is not bailable. Siyempre, magpapile ka muna ng petition for bail. You have to show that the evidence of guilt is not strong para makapag-avail ka ng bail. Pero initially, the offense is not bailable. If the offense is punishable by reclusion perpetua. Pero siyempre, yung rules on criminal procedure extended the offense which is non-bailable. So pag binasa niyo yung criminal procedure, ang non-bailable, yung offense punishable by reclusion perpetua, life imprisonment or death. Ba't nagkaganon? Kasi yung life imprisonment is a penalty graver than that of reclusion perpetua. Bakit? Ang reclusion perpetua, you will apply kasi yung ano diyan eh, yung threefold or yung 40 years limitation rule under Article 70 of the Revised Penal Code. Hanggang 40 lang yan. Pero ang life imprisonment, hindi applicable yung Article 70. Unlimited yan. Life talaga yan. Kaya nga yung life imprisonment is a penalty greater than that of reclusion perpetua. And kaya yung sa rules of criminal procedure, sinama ng Supreme Court yung offense which is non-bailable if it is punishable by life imprisonment. Why? Kasi basic naman, ano lang yan kumbaga yung logic lang naman yan. If an offense punishable by reclusion perpetua is not bailable, so it follows that an offense which punishable by life imprisonment, which is graver than reclusion perpetua, is not also bailable. Kasi to rule otherwise, di ba, it will create an absurd situation where the offense punishable by reclusion perpetua is non-bailable, while an offense punishable by a graver penalty, such as life imprisonment, is bailable. Magiging absurd po siya. Pag reclusion perpetua, hindi sa bailable. Pag mas malaki yung penalty, magiging bailable na. That is the reason why na sinabi ng Supreme Court na if the offense is punishable by reclusion perpetua or life imprisonment or death, hindi siya magiging bailable. Na? Okay tayo dyan. Now, in the case of People versus Valdez, ang sabi ng Supreme Court, di ba ang wording sa Section 13 ng Article 3 of the Constitution, offense punishable by reclusion perpetua. So according to the Supreme Court in the case of Valdez, the word punishable means that for purposes of determining whether the crime is bailable or not, you will consider the prescribed penalty, not the imposable penalty after taking into consideration the modifying circumstance. Na? So for purposes of determining whether the crime is bailable or not, you will consider the prescribed penalty. No? The prescribed penalty, not the imposable penalty after taking into consideration modifying circumstance as established by evidence. No? Yung prescribed penalty nasa batas na yan eh. Yung imposable penalty, kukonsider mo ba yung modifying circumstance? Pero i-establish mo pa yung by evidence. No? By evidence. Now, ano ba yung pagkakaiba ng prescribed penalty at imposable penalty? Ang prescribed penalty, pag halimbawa ang pinag-uusapan natin is felony under the revised penal code, ang prescribed penalty, that is the penalty prescribed in Book 2, no? In the provision of the revised penal code, Book 2, no? After defining a felony, no? So for example, under Article 249 of the revised penal code, that provision defines the felony of homicide and prescribe the penalty of reclusion temporal. No? So yung reclusion temporal prescribed by Article 249 of the revised penal code after defining homicide, that is the prescribed penalty. Yon. Now, ano yung imposable penalty? Kasi magkukonsider ka ng mga modifying circumstances. No? Such as quasi-recidivism under Article 160, privilege mitigating circumstance of minority under Article 68, no? At saka yung, alam mo, yung complex crime under Article 48 of the revised penal code, kasi pag complex crime siya, that is a modifying circumstance in the sense that you will apply the penalty prescribed for the most serious components in its maximum period. No? So pag nag-consider ka ng provision, other than the provision defining a felony, prescribing a penalty for it, pag nag-consider ka ng other provision, no? yung penalty after taking into consideration other provision on modifying circumstance, ang tawag dan imposable penalty. Now, halimbawa ganito. In the case of People versus Valdez, ang charge sa kanya is complex crime of malversation through falsification of public documents. Yon. Now, ano yung prescribed penalty for malversation? Tingnan mo yung provision defining malversation. That is Article 217 of the Revised Penal Code. Itong kaso ng Valdez case, wala pa yung RA 10951, no? So, i-consider natin yung penalty under the old version of Article 217. So, nakalagay sa Article 217, pag nag-exceed ng 22, prior to the amendments, pag nag-exceed ng 22,000 pesos, yung property na minalverse mo. Ang penalty for malversation is reclusion temporal in its maximum period to reclusion perpetua. So ayun yung prescribed penalty, no? So since na ang kinonsider mo yung Article 217 defining malversation, ang tawag doon sa penalty mentioned in Article 217, ayun yung prescribed penalty, no? So reclusion temporal in its maximum period to reclusion perpetua. Ngayon, pero kasi naka-complex siya malversation through falsification of public document. So, i-consider mo siyempre yung Article 48 of the Revised Penal Code. Di ba pag complex crime, you will apply the penalty for the most serious component, that is malversation, in its maximum period. So yung maximum period ng reclusion temporal in its maximum period to reclusion perpetua is reclusion perpetua. So ang imposable penalty is reclusion perpetua. So nagdalawa na ang penalty rito. Yung first penalty, prescribed penalty. Yung prescribed penalty, kukonsider mo yung Article 217. So ano yung prescribed penalty? So sa Article 217, ang prescribed penalty for malversation is reclusion temporal, maximum period to reclusion perpetua. Now, ano yung imposable penalty? Ang imposable penalty, pag na-approve ng prosecution that the crime committed is a complex crime. Applying Article 48 of the Revised Penal Code, you will apply the penalty for malversation, prescribed for malversation in its maximum period. And that is reclusion perpetua. So ang imposable penalty is reclusion perpetua. So ulitin ko dalawa yung penalty rito. Yung prescribed penalty, reclusion temporal in its maximum period to reclusion perpetua. At saka yung imposable penalty, and that is reclusion perpetua. Now, for purposes of determining bail, you will not consider the prescribed penalty of reclusion temporal, maximum period to reclusion perpetua. But you will consider the imposable, you will consider the prescribed penalty, and that is reclusion temporal, maximum period to reclusion perpetua. You will not consider the imposable penalty, that is reclusion perpetua. Kaya ang sinabi ng Supreme Court, this is bailable. Why? Kasi pag kinonsider mo yung imposable penalty, reclusion perpetua, hindi sa bailable, di ba? Pero pag kinonsider mo yung prescribed penalty, that is reclusion temporal, maximum period to reclusion perpetua, bailable siya. So ang i-consider mo yung prescribed penalty. The prescribed penalty of reclusion temporal, maximum period to reclusion perpetua. And therefore, that is bailable. Alam mo, prior to the Valdez case, merong DOJ guidelines on bail. Pag malversation through falsification of public documents, bailable yan. But because of the case of Valdez, dati kasi hindi sa bailable. I'm sorry. Dati hindi sa bailable under the guidelines ng DOJ. But because of the case of People versus Valdez, nagiging bailable na siya. Now, what is now the lesson? Ang lesson is that to consider the crime as bailable. No? The prescribed penalty must be purely reclusion perpetua. Purely life imprisonment, purely death. Pag ang penalty is a combination of a divisible penalty and reclusion perpetua, applying the case of Valdez, magiging bailable yan. No? Halimbawa, yon. The crime committed is the accused is charged of treason committed by a resident alien. No? Under Article 114 of the Revised Penal Code, ang penalty niyan reclusion temporal, no? To death, reclusion temporal to death. Now, applying the case of Valdez, bailable siya. No? Kasi para maging non-bailable yan, dapat ang penalty, reclusion perpetua, life imprisonment, or death. Pag ang penalty, no, is a combination of an divisible at indivisible penalty, such as reclusion temporal to death, bailable yan. Halimbawa, yung sexual abuse under Section 5B of RA 7610. Ang penalty niya is reclusion temporal, medium period to reclusion perpetua. Bailable ba siya? Bailable. No? Kasi yung penalty niya hindi purely reclusion perpetua. Now, under Section 11 of B of RA 9165, ito yung pinag-uusapan pag yung possession ng shabu is 5 grams, no? 5 grams siya. But less than 10 grams. O kung marijuana naman is 300 grams but less than 500 grams. Pag binasa niyo yung Section 5B of RA 9165, ang penalty nito is 20 years, 1 day to life imprisonment. No? Yun. 20 years, 1 day to life imprisonment. Ang tanong, alam mo ito may practice kasi sa NCR na pag ang penalty for possession of dangerous drugs is 20 years, 1 day to life imprisonment. Ang findings ng fiscal, that is non-bailable. Kaya ang nakalagay nila dun sa resolution nila, no bail recommended. At yung mga RTC judge, hindi nila, since na no bail recommended, so okay na yun. Hindi nila ina-allow na mag-bail. O siguro yung iba ina-allow. Pero yun ang practice sa NCR. I respect the prosecutors in NCR, the fiscal ako dati, I respect yung mga RTC judges. Pero ito po yung opinion ko. Ang opinion ko, applying the case of People versus Valdez. No? You always consider the prescribed penalty for purposes of determining whether the crime is bailable or not. Ang prescribed penalty niya hindi life imprisonment Ang prescribed penalty niya 20 years and 1 day to life imprisonment. So hindi siya non-bailable, bailable siya. No? Bailable po siya. That is my submission. No? Kasi in the case of Valdez, 'di ba? Reclusion temporal maximum period to reclusion perpetua, bailable. So 'di ba? So ganun din. Kung 20 years, 1 day to life imprisonment, bailable din 'yan. Kasi you will consider the prescribed penalty. Dapat ang prescribed penalty life imprisonment lang. Hindi pwede 20 years, 1 day to life imprisonment. Pag life imprisonment, non-bailable. Pag 20 years, 1 day to life imprisonment, bailable. Ganun din, kung reclusion perpetua, non-bailable. Pero reclusion temporal, maximum period to reclusion perpetua, bailable yun. Na? That is the case of People versus Valdez. Now, meron bang exception sa People versus Valdez? Meron pong exception. Ano po yung exception niya? First, there are two exceptions. Yung first exception is yung privilege mitigating circumstance of minority. Halimbawa ganito. You commit murder. No? Now, what is the prescribed and the offender is a child in conflict with the law. He's a minor. The crime committed is murder. Now, what is the prescribed penalty? What is the imposable penalty? Na? Ang prescribed penalty, so you have to consider the provision defining murder. So sa Article 248 of the Revised Penal Code, reclusion perpetua to death. What is the imposable penalty? Siyempre, you will consider modifying circumstance. You will consider a provision other than Article 248 of the Revised Penal Code, such as Article 68 ng RPC. Di ba under Article 68 of the Revised Penal Code, yung privilege mitigating circumstance of minority, you will graduate the penalty 1 degree lower. That is reclusion temporal. No? So if murder is committed by a minor, there are two penalties. The prescribed penalty and the imposable penalty. What is the prescribed penalty? Reclusion perpetua to death. No? So, hindi available. What is the imposable penalty? Reclusion temporal. No? So, available siya. Bakit imposable siya? Kasi pag kinonsider mo na yung privilege mitigating circumstance of minority after proving that the accused is a minor. Na? Now, kasi pag kinonsider mo yung Valdez case, for purposes of determining whether the crime is bailable or not, you will consider the prescribed penalty of reclusion perpetua to death, not the imposable penalty of reclusion temporal after taking into consideration the privilege mitigating circumstance of minority. Pag in-apply mo yung Valdez case, pero this is an exception to the case of Valdez. Why? Because of Section 34 of RA 9344. No? Ano nakalagay sa Section 34 of RA 9344? The privilege mitigating circumstance of minority shall be considered by the court in fixing the amount of bail. No? So in other words, in determining whether the crime is bailable or not, you will consider the privilege mitigating circumstance of minority. Bababa sa 1 degree. So for purposes of bail, you will consider the imposable penalty of reclusion temporal because of Section 34 of RA 9344. No? And therefore, bailable yan. Dati meron akong kaibigan dati na abogado siya, sabi niya, Judge, idol, acquitted yung kliyente ko, ang kaso rape. No? Naawa nga ako eh, ilang taon na nakakulong. Sabi ko, bakit ilang taon nakakulong? Eh, siyempre, while the case is pending, hindi kami nakapagpiansa. Non-bailable yan eh. Sabi ko, pare, huwag mo na lang sabihin sa kliyente mo. Bailable yan. Oo, because of Section 34 of RA 9344. Although ang prescribed penalty niya is reclusion perpetua, under RA 9344, you will consider the privilege mitigating circumstance. So, bababa ka, reclusion temporal. So, for purposes of bailability, you will consider reclusion temporal. And therefore, that is bailable. No? Sabi niyo, hindi ko na lang sasabihin sa kliyente ko. So, okay na tayo dyan, no? Ang isa pang exception, kung halimbawa, ang charge sa kanya is yung frustrated murder, attempted murder, o murder committed by an accomplice or an accessory. No? Halimbawa ganito. Pag sinarge siya ng frustrated murder, ano yung prescribed penalty? Ano yung imposable penalty? Yung prescribed penalty, ayun nga, yung nakalagay sa Article 248 of the Revised Penal Code, reclusion perpetua to death. Ang imposable penalty, you have to consider modifying circumstance, such as Article 50 of the Revised Penal Code, bababa ka 1 degree lower. So, from reclusion perpetua to death to reclusion temporal. Ngayon, settled na po yan. Pag ang charge is frustrated, attempted murder, or is being charged as an accomplice or as an accessory, pinapayagan po magpiyansa yan. You will consider not the prescribed penalty of reclusion perpetua to death for murder, but you will consider the imposable penalty, taking into consideration the modifying circumstance, no? Or the graduating circumstance under Article 50, kasi frustrated siya 1 degree lower. So for purposes of bailability, you will consider the imposable penalty of reclusion temporal. Na? So okay na tayo. Okay na tayo dyan. Now, dito tayo sa section 98 of RA 9165. Ano pong nakalagay doon? Notwithstanding any law, rules, or regulation to the contrary, the provision of the Revised Penal Code shall not apply to the provision of this act except in cases of minor offenders. So, merong dalawang rule dito. Yung rule kung yung offender is an adult. Yung second naman, yung rule if the offender is a minor. So, dalawa yung rule sa section 98 of RA 9165. Rule if the offender is a minor, and rule if the offender is an adult, tsaka rule if the offender is a minor. Dito muna tayo sa first rule. The offender is an adult. He is not a minor. So what is the rule? The rule is that notwithstanding any law, rule, or regulation to the contrary, the provision of the Revised Penal Code shall not apply to the provision of this act. No? So hindi siya pwedeng maging supplementary. Di ba pag binasa mo yung Article 10 of the Revised Penal Code, yung provision of the Revised Penal Code shall apply to an offense punishable under special law unless unless it provides it expressly provide the contrary. No, so in other words, pag ang pinag-uusapan is dangerous drugs, no? A crime involving dangerous drugs committed by an offender who is not a minor, you will not apply Article 10 of the Revised Penal Code on supplementary application of the provision of the Revised Penal Code, but you apply Section 98 of RA 9165, which prohibits the application of the provision of the Revised Penal Code. Na? Yon. Ngayon. So, for example, under Article 29 of the Revised Penal Code, di ba pag meron kang preventive imprisonment while the case is pending, nakakulong ka, no? Nakakulong ka. Di ba pag meron kang preventive imprisonment, kinikredit yun dun sa ano mo na talaga, pag na-convict ka na, pag magsiserve ka na ng penalty, kinikredit yun under Article 29. Now, ito ang practice sa NCR, hindi ko alam sa probinsya, pero malamang ganun din practice. Yung mga judges, kinikredit yung preventive imprisonment. No? Doon sa pagsiserve ng penalty, pag convicted na yung yung akusado of a crime involving dangerous drugs. That is the practice. No? Pero for purposes of the bar examination, you cannot apply Article 29 of the Revised Penal Code on crediting preventive imprisonment to the service of penalty for a crime involving dangerous drugs because of Section 98 of RA 9165. Now, di ba sa Article 39 of the Revised Penal Code, pag merong penalty of fine, kino-convert into subsidiary imprisonment. Kasi halimbawa, ang crime committed is illegal possession of paraphernalia. Ang penalty niyan is for 6 months and 1 day to 4 years. Tapos meron pang penalty of fine yan. No? Ang tanong, pag hindi siya nagbayad ng fine, kasi sa mga na I heard sa mga sa practice may mga RTC judges is that pag hindi nagbayad ng fine, wala, hindi nila papakawalan. Pag hindi mo pinakawalan yan, as if you are converting fine into subsidiary imprisonment. Hindi siya convertible into subsidiary imprisonment. Why? Because of Section 98 of RA 9165, the provision of the Revised Penal Code, which definitely includes Article 39 of the Revised Penal Code on conversion of fine into subsidiary imprisonment, shall not apply to RA 9165, which punish illegal possession of paraphernalia. Pag halimbawa hindi nakabayad ng fine, tapos although in fairness to the RTC judge, baka meron silang interpretasyon. Ito lang yung interpretasyon ko, no, na siguro yung my interpretation is different from the interpretation of RTC judges. So this is my interpretation. I respect them, ha, kasi alam mo kasi mismo sa Supreme Court, di ba, nagkakaroon minsan ng mga dissenting opinion. So normal lang na nagkakaroon ng kanya-kanyang interpretasyon. Pero this is my interpretation, no? So kasi minsan I heard na pag hindi nakapagbayad ng fine, hindi pinapakawalan. Pero ang opinion, baka tama yung opinion nila, pero ang opinion ko is different from the opinion of others. No? Ang opinion ko, ito for purposes of the bar to, applying Section 98 of RA 9165, the Article 39 of the Revised Penal Code on conversion of fine into subsidiary imprisonment is not applicable. No? So, paano na yung fine? Mag-ano ka, writ of execution. Then order the sheriff na maghanap ng property. No? To implement the penalty of fine kung ayaw niya magbayad. No? So, okay na tayo dyan. Now, di ba under Article 39, 97, saka 98 of the Revised Penal Code, merong time allowance, no? Good conduct time allowance, lecture seminar allowance, study allowance, loyalty time allowance, 'di ba? Meron. So, ang tanong, if an offender is convicted of a crime involving dangerous drugs, magkakaroon ba sila ng time allowance to be deducted to the service of their penalty of imprisonment? No. Because of Section 98 of RA 9165. Now, in the case of People versus Chiyong, this is RA 90440-42, October 30, 1992. No? Ang pinag-uusapan rito yung violation of RA 6425. This is the old dangerous drugs law, no? 6425. Now, marami siyang conviction no? O palagay na meron siyang 4 na conviction. Ang tanong, can you apply the threefold and 40 years limitation rule under Article 70 of the Revised Penal Code? No? Kasi marami siyang conviction. Now, according to the Supreme Court in the case of People versus Chong, yes, because of Article 10. Di ba sa Article 10, the provision of the revised penal code shall be supplementary to special law. So in other words, the Article 470 of the revised penal code on threefold rule, no? Because of Article 10 of the revised penal code shall be applicable to an offense punishable under RA 6425. So okay tayo dyan. Now, ang tanong, kung halimbawa the accused is convicted of a crime such as sale of dangerous drugs under the present dangerous drugs law, RA 91 RA 9165, no? So meron siyang palagay na natin anim na conviction. Will you apply the threefold rule under Article 70 because of the case of People versus Chong? Ito lang, opinion ko lang po. This is my opinion. The case of People versus Chong, what is involved is violation of the old dangerous drugs law, no? Which is already repealed by RA 9165. Now, applying RA 9165, no? Section 98. The provision of the revised penal code shall not apply to RA 9165. So in other words, Article 70 on threefold rule, hindi applicable. So kung halimbawa ang penalty niya ay meron siyang 6 na life imprisonment for sale of dangerous drugs under Section 5 of RA 9165, he will serve, no? Isi-serve niya lahat yun. Na? Yun ang ang opinion ko. Kasi yun ang nakalagay, Section 98. Now, okay na tayo dyan. Now, halimbawa ganito. At so ano yung pag halimbawa sa illegal possession of dangerous drugs under Section 11, iba-iba yung penalty niyan eh. Sa paragraph A, life imprisonment. Sa paragraph B, 20 years 1 day to life imprisonment. Sa paragraph C, at 12 years 1 day to 20. Iba-iba yung penalty niya, no? Depende kasi kung yung ilan yung gramo, no? So rito muna tayo sa Section 11 Section 11C of RA 9165. So ito pag ang pagshabu dapat ang gramo niya is 10 grams or more. Pag marijuana 500 grams or more. I'm sorry kasi ano pala to, ano? Yung C pala to. Dapat ang gram niya is not more than less than 5 grams pag shabu. Tapos less than 300 grams kung marijuana. So ang penalty niya is 12 years 1 day to 20. For purposes of the bar, you don't have to memorize. Kasi pagdating sa bar, yung specific penalty ng RPC tsaka ng special law, hindi sa covered. So kung magtatanong sila ng penalty, given yon. So ilalagay nila given. So the accused is charged of possession of dangerous drugs where the penalty is 12 years 1 day to 20 years. Now, sa Islaw law, merong first rule tsaka second rule. Yung second rule, yung first rule RPC. Yung second rule, offense punishable under special law. Ang tanong, pag yung offense ba is punishable under special law, automatic you apply the second rule. Kasi pag binasa mo yung Islaw pag RPC first rule, pag special law second rule. Pero ang tanong, if the offense is punishable under special law, automatically you will apply the second rule. You will not. Why? Because of the case of People versus Simon. This is GR number na 93028 July 29, 1994. Na? People versus Simon. Sa People versus Simon, if the offense is punishable under special law, and the special law adopts the technical nomenclature of the penalty of the revised penal code. Na? So if that is the situation, you apply the penal provision of the revised penal code, including the first rule of the ISLAW. Na? Yon. Now, second rule sa People versus Simon. If the special law did not adopt the technical nomenclature of the penalty of the revised penal code, you will not apply the provision of the revised penal code. So with respect to ISLAW, you apply the second rule. Na? So in other words, if the offense is punishable under special law, hindi automatic you apply the second rule sa ISLAW. Titingnan mo muna, if the offense punishable under special law and the special law adopts the technical nomenclature of the penalty of the revised penal code, you apply the first rule sa ISLAW. If the special law did not adopt the technical nomenclature of the penalty of the revised penal code, you apply the second rule. Pero yung second rule, applicable lang yan pag mayroong maximum saka minimum limits. So, now, what is the second rule? Under the ISLAW law. What is the second rule? Ito po yung second rule. The maximum penalty shall not exceed the maximum limits prescribed by law, while the minimum penalty shall not be less than the minimum limits prescribed by law. So in other words, if the penalty prescribed for illegal possession of dangerous drugs is 12 years, 1 day to 20 years, applying the ISLAW law, the maximum penalty shall not exceed 20 years. While the minimum penalty shall not be less than 12 years and 1 day. So in other words, the court can sentence the accused to 12 years, 1 day as, of imprisonment as minimum penalty, to 20 years as maximum penalty. O pwede niya sabihin at 14 years of imprisonment as minimum penalty to 18 years of imprisonment as maximum penalty. Na? So, ganun po yun. So, pwedeng 11 years of imprisonment as minimum penalty to 19 years of imprisonment as maximum penalty. Pero ito for purposes of the ban, para hindi masyadong complicated, gawin nyo na lang eksakto. Pwede naman eksakto. Pwedeng gawin yung 12 years, 1 day of imprisonment as minimum penalty to 20 years as maximum penalty. So, ito yung, So, ito lang, pag ganun ang tanong, ito yung sasabihin nyo, Applying the first rule, the second rule of the ISLAW, the maximum penalty shall not exceed the maximum limits prescribed by law, while the minimum penalty shall not be less than the minimum limits prescribed by law. In other words, the maximum penalty shall not exceed 20 years of imprisonment, while the minimum penalty shall not be less than 12 years, 1 day of imprisonment. If I'm the judge, I will sentence the accused to 12 years and 1 day of imprisonment as minimum penalty to 20 years as maximum penalty. Na? Okay na tayo dyan. Okay na tayo dyan. Now, sa yung section 11B of RA 9165, ang penalty niyan is 20 years and 1 day to life imprisonment. 20 years, 1 day to life imprisonment. Ang gramo niyan, pag shabu, 5 grams, less than 10. Pag marijuana, 300 grams, less than 500. Na? Pero you don't have to memorize that. Ha? Sinasabi ko lang, pagdating sa bar, dapat given yan. No? Dapat given po siya. So, halimbawa, tinanong sa bar, ang penalty is 20 years and 1 day to life imprisonment. Na? So, ang tanong, applicable ba yung ISLAW? Na? Applicable ba yung ISLAW? Before, yung old rule, that is the case of People versus Padilla, hindi applicable yung islaw kasi sinabi ng Supreme Court that is an indivisible penalty and therefore the islaw is not applicable. So yung old rule, pwedeng ang penalty mo is 20 years and 1 day or ang penalty mo is life imprisonment. Na? Yon. Pero ngayon, nag-iba na ang rule. Why? Because of the case of obvious, people versus obvious, saka people versus pisan. Na? Yung people versus obvious, that is GR number 2222187, March 25, 2019. Yung people versus pisan is 242692. 2022 eh. At July 13, 2020, no? So pisan tsaka obvious. Now, ano yung rule? There are two rules, the general rule and the exception. Ano yung general rule? Ang general rule, you apply the islaw. Ano yung exception? You impose life imprisonment. Na? So ang general rule is you apply the islaw. Ang exception, you impose life imprisonment. So dito muna tayo sa general rule. No? Pag ang kaso niya is section 11B of RA 9165, you apply the general rule, apply the islaw. Pero, so kailan pumapasok yung exception? Ang exception, kung ang kaso niya is section 13 in relation to section 11B of RA 9165. So, possession of dangerous drugs during parties, gathering, or social gathering or meeting. Ano ba yung parties, gathering, or social gathering or meeting? Sa implementing rules ng DOJ, meron sila, if the accused is accompanied with at least 2 persons. So, at least tatlo sila, isang offender, tapos meron siyang kasamang dalawa, meron ng social gathering meeting, no? Or parties. So dapat at least tatlo, isang offender tapos may kasama siyang at least 2. So magtatatlo sila. No? So yun, ulitin ko ang general rule apply the islaw. Pag general rule section 11 yan, B of RA 9165. Ang exception, no? Section 13 in relation to section 11B of RA 9165. So dito muna tayo sa general rule. So sa general rule, section 11B of RA 9165, no? Hindi in relation to section 13, no? Basta section 11B of RA 9165. So what is the general rule? Apply the islaw law. Now, so what is the maximum penalty? Ang maximum penalty is not life imprisonment. Why? Yung maximum penalty under the islaw law, under the indeterminate sentence law, is not life imprisonment. Why? Kasi di ba sa life imprisonment, specifically mentioned na pag life imprisonment, islaw is not applicable. So rule out ang life imprisonment as maximum penalty under the islaw. Now, according to the Supreme Court, if the penalty exceeds 40 years, that is equivalent to life imprisonment. So hindi din pwedeng mag-i-exceed ng 40 years. Why? Kasi pag nag-40 years in 1 day, that is equivalent to life imprisonment, sabi ng Supreme Court, and therefore hindi siya allowed. So what is the maximum penalty under the islaw if the crime committed is possession of dangerous drugs under section 11B of RA 9165? The maximum penalty must not exceed 40 years. Okay tayo dyan. Now, what is now the minimum penalty under the islaw? Ay, di ba, ang prescribed penalty niya, 20 years, 1 day to life imprisonment. So, ang minimum penalty niya is not less than 20 years and 1 day. So, in other words, applying the second rule of the ISLAW, the maximum penalty shall not exceed 40 years, while the minimum penalty shall not be less than 20 years and 1 day. So, in the case of Pisan saka yung Ubias, ang penalty nila is 20 years and 1 day of imprisonment as minimum penalty to 30 years as maximum penalty. Pero pwede mag-40 din yun. Na? Okay na tayo dyan. Okay na tayo dyan. Ngayon, dito tayo sa exception. Ang exception, pag ang pinag-uusapan is illegal possession of dangerous drugs during parties, social gathering, or meeting under Section 13 in relation to Section 11B of RA 9165. Ano yung penalty? Kasi pag binasa mo yung the case of Obias, no? Binanggit ng ponente yung opinion ni Justice Mario Lopez at pag merong possession of dangerous drugs during parties, social gathering, saka meeting under Section 13, you will apply the penalty in its maximum period. You will apply the penalty under Section 11 in its maximum period. So what is the penalty? No? What is the maximum period of the penalty of 20 years and 1 day to life imprisonment? Di life imprisonment. So, yun ang penalty, life imprisonment. Ha? So, okay na tayo. Okay na tayo dyan. Okay na tayo dyan. Now, dito tayo, di ba pinag-uusapan natin is Section 98 of RA 9165 if the offender is not a minor or the offender is an adult. So dito tayo sa second rule ng Section 98 of RA 9165. The offender is a minor. So if the offender is a minor, what is the rule? The provision of the revised penal code shall apply to the provision under RA 9165. Why? Yun nga, kasi because of Section 98 of RA 9165, notwithstanding any law, rule, or regulation to the contrary, the provision of the revised penal code shall not apply to the provision of this act except in cases of minor offenders. So pag minor offender, you apply the provision of the revised penal code. Now, alam mo ganito, the crime committed is sale of dangerous drugs where the penalty is life imprisonment. Sale or possession, basta ang penalty niya is life imprisonment. The offender is a child in conflict with the law. He is a minor. Now, kung judge ka, what penalty will you impose? Ganito muna. No? Under Section 98 of RA 9165, if the penalty is life imprisonment, the offender is a minor, life imprisonment shall be converted into reclusion perpetua. No? Why? Kasi nga, you apply the penal provision of the revised penal code. If the offender is a minor, hindi mo ma-apply yung provision, yung penal provision ng revised penal code if the penalty is not Spanish penalty. Kung ang penalty is American, hindi mo. Kasi ang penalty sa RA 9165, mga American penalty yan. So, i-convert mo muna into Spanish penalty. So, kung ang pinag-uusapan is a sale or possession of dangerous drugs and the penalty is life imprisonment, the offender is a minor, you convert first the penalty. So, life imprisonment converted into reclusion perpetua. Now, ang tanong, can you appreciate the privilege mitigating circumstance of minority under Article 68 of the revised penal code? Yes. Why? Because of the case of People versus Muntalaba. This is GR number 186227, July 20, 2011. No? So there are two reasons why the privilege mitigating circumstance of minority under Article 68 of the Revised Penal Code shall be considered by the court in the imposition of penalty. Why? Now, first, the case of People versus Simon. If the special law adopts the technical nomenclature of the penalty of the Revised Penal Code, you apply the provision, no, the penal provision of the Revised Penal Code. So since the penalty of life imprisonment shall be considered as reclusion perpetua because of Section 98 of RA 9165. So in other words, the special law adopts the technical nomenclature of the penalty of the Revised Penal Code, no? So the provision of the Revised Penal Code, including Article 68 on privilege mitigating circumstance of minority, shall be considered by the court. So bababa ka 1 degree lower from reclusion perpetua to reclusion temporal. Na? Tapos niya, sa Islaw, you apply the first rule. So you will apply the penalty, no, in its medium period kung walang confession. O halimbawa, may confession, so you apply the penalty in its minimum period. No? So yung ganon. Ganon ang ano doon. Now, di ba, kung ang penalty is life imprisonment, wala tayong problema, pwedeng gagawing reclusion perpetua yan. Pero di ba mayroong penalty, 20 years, 1 day to life imprisonment. Halimbawa, the offender is a minor. Sa akin is that, this is my opinion. If the penalty is 20 years and 1 day to life imprisonment, the offender is a minor, you can convert that into reclusion perpetua. No, disregard na natin yung 20 years and 1 day. So, reclusion perpetua. No? So, pwede mo nang ibabayan reclusion temporal because of the privilege mitigating circumstance of minority. Now, halimbawa, ang penalty niya is 12 years, 1 day to 20. Di ba? Illegal possession. Meron yan, di ba? Sa ano yung section 11 ng paragraph C ng RA 9165. 12 years, 1 day to 20. So, the accused is minor. So, i-convert mo muna. How can you convert that? Yung 20 years, 1 day to 20, that is reclusion temporal. 1 degree lower, magpiprison ba yun? Na? Pero ito merong tinanong sa bar, illegal possession of paraphernalia. The offender, no, is a minor. Ang penalty niya is 6 months and 1 day to 4 years. Hindi pala natanong sa bar to, pero halimbawa itanong sa bar. So, if the offender is a minor, can you appreciate the privilege mitigating circumstance of minority? You cannot. Why? Kasi to appreciate the privilege mitigating circumstance of minority, the penalty must be graduatable. And to consider the penalty as graduatable, the penalty must be a Spanish penalty. So, i-convert mo muna yung American penalty to Spanish. Halimbawa, yung 20 years, yung 12 years, 1 day to 20, convert mo to Spanish penalty, so reclusion temporal, so pwede mo nang appreciate yung privilege mitigating circumstance of minority, 1 degree lower, magpiprison mayor. Kasi yung reclusion temporal, graduatable yun. Pag ang penalty mo 6 months, 1 day to 4 months, problema hindi sa graduatable, hindi sa convertible. Wala siyang equivalent ng Spanish penalty. Okay lang sana kung 6 months, 1 day to 4 years and 4 years and 2 months. Pwede mo i-convert yan. Ang conversion niya, prison correctional minimum period to medium period. And that is 6 months, 1 day to 4 years and 2 months. Kaso yung penalty for illegal possession of paraphernalia, 6 months, 1 day to 4 years. Wala siyang equivalent sa Spanish penalty. And therefore, you cannot appreciate the privilege mitigating circumstance of minority. Kasi hindi sa convertible. Na? Kung sana, kung 6 months, 1 day to 4 years and 2 months, pwede mo i-convert yan to prison correctional minimum medium period. 1 degree lower is arresto mayor medium maximum period. So you can consider the privilege mitigating circumstance of minority. Na? Ayun. Now, ito pala tinanong sa bar. The crime committed illegal use of dangerous drugs under Section 15. Oh, ang tanong, can you appreciate the privilege mitigating circumstance of minority? Ang problema, ang penalty niyan, pag first time offender is rehabilitation. Hindi siya convertible into Spanish penalty. And therefore, despite of the mandate under Section 98 of RA 9165 that the provision of the revised penal code shall apply to the provision under RA 9165. No? You cannot apply Article 68 of the revised penal code on the privilege mitigating circumstance of minority if the crime is use of dangerous drugs under Section 13 of RA 9165. Kasi hindi mo siya mako-convert into Spanish penalty. Hindi mo siya pwedeng i-graduate. At saka, ang rehabilitation, hindi mo na pwede i-graduate yan. Paano mo ma-rehabilitate siya kung masyado nang mababa yung period, di ba? Pababa ka pa dyan. Paano mo ma-rehabilitate yan? It takes time to rehabilitate a drug dependent. Na? Ayon. So okay na tayo dyan. Now, dito tayo sa section section 23 ng RA 9165, section 23. Sa section 23 ng RA 9165, ang nakalagay po doon, no? A person charged of crimes involving dangerous drugs, regardless of the imposable penalty, cannot avail the provision on plea bargaining. Palaging tinatanong sa variant dati. No? He is charged of sale or possession of dangerous drugs. Can he avail plea bargaining? No. Why? Because of Section 23 of RA 9165. A person charged of a crime charged with a crime involving dangerous drugs cannot avail, no, the provision on plea bargaining. Now, kaso in the case of Estepona Jr. versus Lubriga, no, this is GR number 2266 79 at August 15, 2017. No? So, sabi ng Supreme Court, unconstitutional yung Section 23 ng RA 9165. Bakit siya unconstitutional? Ganito yan. Sa Section 5 ng Article 10 ng 1973 Constitution. Section 5, Article 10 ng 1973 Constitution. Ang nakalagay po doon, the Supreme Court shall have the power to promulgate pleadings, practice, and rules. No? The Supreme Court shall have the power to promulgate practice, pleadings, and procedure, which may be alter, repeal, or supplemented by the batasang pambansa. No? So in other words, the powers to make procedural rules or yung power to make procedural rules belongs not only to the Supreme Court but also to batasang pambansa. No? Shared ang power nila. No? Kasi which may be altered, repealed, or supplemented by the batasang pambansa. No? Nasa 1973 Constitution. However, under Section 5 of Article 8 of the 1987 Constitution, no? Ang nakalagay doon, the Supreme Court shall have the power to promulgate pleadings, practice, and procedure. Wala nang nakalagay doon that which may be altered, repealed, or supplemented by Congress. Wala. Wala nakalagay doon. Kaya in the case of Istipona, ang sabi ng Supreme Court, no? Taking into kasi kumbaga yung hindi kinopya yung phraseology regarding the power of batasang pambansa to alter, repeal, and supplement the rules of court was not adopted by the 1987 Constitution. And therefore the power to make procedural rules is the exclusive domain, no, of the Supreme Court under the 1987 Constitution. No? Hindi na yung power to yung rule making power by the Supreme Court is not a shared power, no? Hindi na shared power by the executive and by the legislative department. No? Exclusive domain ng Supreme Court. Wala nang pakialam ang executive at saka legislative. At ako with due respect to the Supreme Court, I will side with the opinion of Justice Herrera, no? Kasi ang ini-explain ni Justice Herrera, no? Iba yung opinion niya. Pero siyempre I respect the Supreme Court, and for purposes of the bar, we have to follow the Supreme Court decision. Kasi pag binasa mo yung section section 10, article 15, article 18, no? Section 10, article 18 of the Constitution, 1987 Constitution. Nakalagay po doon na yung rules of the existing rules of court, Judiciary Act, and procedural law not inconsistent with the Constitution shall remain operative unless repealed or amended by the Supreme Court or Congress. No? So in other words, no, pag binasa mo yung section 10 ng article 18 of the 1987 Constitution, yung Congress has the power to alter or to repeal, no, or alter the existing rules of court. No? Pero siyempre, for purposes of the bar, we follow the Istipona. So according to the Supreme Court in the case of Istipona, no, yung the rule on plea bargaining is procedural, is a procedural in character. The rule on plea bargaining is procedural in character, and therefore Congress cannot modify the provision on plea bargaining through Section 23 of RA 9165. No? So that is an encroachment of the rule-making power of the Supreme Court by legislating matters which is procedural in character. Bawal yun, sabi ng Supreme Court. So dineclare na yung Section 23 ng RA 9165 as unconstitutional. Unconstitutional. So because of this, pwede nang magkaroon ng plea bargaining. Now, ang Supreme Court nagpakawala ng guidelines on plea bargaining. Ang DOJ nagpakawala din ng guidelines on plea bargaining. This is a reaction to the case of Estipona. Since na-allow na ang plea bargaining even if the crime involves dangerous drugs under RA 9165, nagpakawala ng guidelines sa Supreme Court ng plea bargaining involving RA 9165. Nagpakawala din ang DOJ, yung latest ng DOJ, yung DOJ Circular number 18. Yung circular ng Supreme Court on plea bargaining hindi compatible sa circular ng DOJ on plea bargaining. That is DOJ Circular number 18. Ngayon, sino ang controlling? Yung circular ng Supreme Court, yung circular ng DOJ. In my submission, yung circular ng DOJ ang controlling. Why? Because of the case of Real, People versus Real 4. This is GR number 247575 at November 16, 2020. Ano sinabi ng Real 4? Ang sinabi ng Real 4, pag merong plea bargaining involving RA 9165 at walang consent yung fiscal, that plea bargaining is null and void. Even the judgment rendered based on the plea bargaining made by the accused without the consent of the fiscal will not attain finality. Null and void. Pag walang consent yung fiscal. Bakit kailangan ng consent ng fiscal sa plea bargaining? Alam mo yung plea bargaining, parang similar yan sa compromise agreement in a civil case. Ang compromise agreement, this is an agreement between the plaintiff and the defendant. The court is not a party to the compromise agreement. No? Ang party sa compromise agreement yung plaintiff at defendant. What is the function of the court in relation to that compromise agreement? The function of the court in relation to a compromise agreement entered into by the defendant and the plaintiff is to approve or not to approve the compromise agreement. If the compromise agreement is not contrary to law, public morals, public policy, etc., the court will approve that. Otherwise, he will not approve. So pag in-approve niya, he will render the judgment based on compromise agreement. Na? Ngayon, ang korte, hindi siya party doon. Hindi siya kasama. Ina-approve lang niya yan o reject niya. Ang party sa compromise agreement, yung plaintiff at defendant. Ngayon sa plea bargaining agreement, ang tawag sa plea bargaining agreement. Ganun din yan. Ang plea bargaining, that is an agreement between the public prosecutor and the complainant and the accused. Sila ang nagkakaroon ng plea bargaining agreement. Silang tatlo. Ngayon, kung halimbawa yung complainant o yung private complainant or yung offended party is notified and he was not present at that time na nagkaroon ng arraignment, no, o pre-trial, no, pwede yung fiscal na lang mag-enter into a plea bargaining agreement. So yung plea bargaining agreement is between the fiscal and the accused. Kung victimless crime, halimbawa yung illegal possession of dangerous drugs, victimless crime yan eh. Walang offended party dyan. So ang plea bargaining agreement is between the public prosecutor and the accused. No? Ngayon, yung court is not a party to the plea bargaining agreement. Ang function lang niya is either to approve or not to approve yung plea bargaining agreement. Pag walang consent yung fiscal sa plea bargaining agreement, O halimbawa sa dangerous drugs, victimless yan eh. So ang pinag-uusapan lang yung piskal at saka yung akusado. No? Pag walang consent yung piskal sa plea bargaining agreement, walang plea bargaining agreement in effect. Why? How can the accused agree with himself? Dapat it takes two to have an agreement. Di ba? Kasi dun sa in the case of Real 4, ang ginagawa kasi naging practice kasi magpa-file lang accused motion to approve plea bargaining agreement. So yung fiscal mag-o-object, the court will approve. No? A motion to plea to a lesser offense. No? Walang consent yung fiscal. So sabi ng Supreme Court, that is invalid without the consent of the public prosecutor. That is invalid. Now, ngayon, halimbawa ito, hypothetical o tinanong sa ba. Nag-file ng motion yung accused to plead to a lesser offense in accordance with the guidelines of the Supreme Court. Ngayon, yung fiscal ba magko-consent diyan? He cannot. Why? Kasi dun sa DOJ Circular number 18, dapat yung plea bargaining agreement is in conformity with the DOJ Circular number 18. Ngayon, kung halimbawa yung proposed plea bargaining ng akusado is in accordance with the guidelines of the Supreme Court but not in accordance with the guidelines of the DOJ Circular, merong mandate under the DOJ circular for the fiscal not to consent. Pag hindi siya nag-consent, walang plea bargaining agreement because of the case of Real 4. So in other words, para magkaroon ng plea bargaining agreement, ang controlling na yung circular ng DOJ. Dapat yung plea bargaining agreement dapat mag-conform sa circular ng DOJ. Otherwise, mag-o-object yung fiscal at wala ng plea bargaining agreement. Na? Ayon. Now, sa circular ng fiscal, ito yung pwedeng magkaroon ng plea bargaining. Babanggit muna ako ng 3. At yung pag-visitor ka sa yung den, dive, saka resort, visitor. Pero ito pag pinag-uusapan yung crime ng den, dive, saka resort, 3 ang pwedeng offender diyan Yung the one maintaining, employee, at saka visitor. Sa circular yung guidelines dati yung guidelines ng Supreme Court sa plea bargaining, pwede mag-plea bargaining ang employee at saka visitor. Pero sa guidelines ng DOJ, ang pwede lang mag-plea bargaining visitor. Hindi pwede ang employee. Pero may condition yon. Dapat wala sang co-accused being charged for maintaining dive resort for maintaining yung dive or resort. Pag meron siyang co-accused na charged as a person maintaining at yung dive resort the visitor cannot avail the plea bargaining provision under the DOJ circular. Yon. Susunod. Kung ang pinag-uusapan sale ng dangerous drugs, dapat shabu pero yung gramo is 0.99 gram or less. So pag nag 1 gram siya, shabu, hindi na pwedeng mag-plea bargaining. Pag sale. Dapat 0.9. Ang 1 gramo, bigyan ko kayo ng idea. Kasi dati yung pinsan ko kasi nagninegosyo yun sa ng ginto. Ngayon pag wala siyang pang-weigh ng gram, yung 1 palito ng posporo, ayun ang 1 gramo daw yun. No? So, yun. 1 palito ng posporo, 1 gram yun. No? Pero siyempre, estimate lang yun. Pag ano naman, pag marijuana, dapat hindi mag-i-exceed ng 9.9 grams. So in other words, pag 10 grams, hindi ka na pwedeng mag pre-bargaining. No? Bakit nagkaganon? Bakit yung ang bentahan is yung 0.99 grams or less? No? Hindi pwedeng mag pre-bargaining kahit na sale of dangerous drugs yan. Ito meron akong istorya pero hindi to validated by evidence. Haka-haka lang to. May mga haka-haka, no? May mga haka-haka na may mga time, pero hindi lahat may mga time kasi na yung mga law enforcer nagpa-plant sila ng dangerous drugs, which is bawal yon. Siguro meron, baka meron, pero hindi lahat. No, wag naman natin sabihin lahat ng yung mga entrapment operation na yan is illegal. Pero meron daw, may nagsasabi sa akin, ewan ko, hindi ko naman validated, na nagpa-plant sila ng mga drugs. Ngayon, para makapag-plant sila ng drugs, meron silang halimbawa operation at nakakuha sila ng maraming drugs. Hindi validated to So halimbawa nakakuha sila ng 20 grams of shabu. Ang i-report lang daw nila 10 grams. Tapos yung sobra, another 10 grams, yun ang pinangpa-plant nila. Kaya since na ang hirap kumuha ng drugs, pag nag-plant sila, maliit lang. Minsan nga meron mga 0.005, may mga ganun lang, maliit lang. 0.5 grams ganon. Kasi tinitipid nila. Pero hindi validated po 'yan, haka-haka lang 'yon. So in other words, no, may pag sale of dangerous drug at masyadong mababa yung gramo, pinapayagan na lang yung pre-bargaining kasi there is a possibility, although hindi lahat, may possibility na baka mamaya planted lang yun, kaya napakaunti. May possibility, no? Kaya yun, kaya inaalaw nila. Pero no, ulitin ko hindi lahat ng entrapment operation involving dangerous drugs nagpaplanta ng drugs, hindi po lahat yun. Mangilang-ilan meron. At ang base sa unvalidated info na nakakarating sa akin, tinitipid nila yung pinangpaplant nila. No? Kaya sa akin lang, no? At merong possibility na pag mababa yung gramo, kahit na bentahan yan, may possibility na baka planta lang. Kaya payagan na lang mag-plea bargaining. Na payagan na lang mag-plea bargaining, no? Okay tayo diyan. Now, pag possession of dangerous drugs at yung gramo niya yung gramo niya is pag shabu less than 5 grams. Kung marijuana, less than 300 grams. No? Ang penalty lang, so that is possession of possession of dangerous drugs. Ang mababa lang ang penalty niyan. So ang penalty niya is 12 years 1 day to 20 years. Pwede ka din mag-pre-bargaining doon. No? Okay. Ngayon, binanggit ko, di ba, tatlo, di ba? Tatlo. Nag-explain na ako sa inyo na tatlong crimes na pwedeng mag-plea bargaining. First, visitor sa den, dive, saka resort. Pangalawa, yung sale of dangerous drugs na mababa lang yung gramo. 0.99 grams pag shabu, 9.9 grams or less kung marijuana. O pag possession naman, no, kung ang gramo is not more than less than 5 grams pag shabu, less than 300 grams pag marijuana, pwede ka mag-plea bargaining. Saan ka pwede mag-plea bargaining? Pwede ka mag-plea bargaining to the lesser offense of illegal possession of paraphernalia. No? Under Section 12 of RA 9165. Ang penalty lang yan is mababa. 6 months and 1 day to 4 years. Pwede ka pang mag-apply ng probation. That is probationable. Because of the case of Pasqua. No? People versus Pasqua. Ayun. So, ano pa yung pwede kang mag-plea bargaining? Pag ang kaso mo is yung possession of paraphernalia, pwede ka mag-plea, no? So under Section 12 of RA 9165. Pwede ka mag-plea bargaining sa use of dangerous drugs under Section 15. So from imprisonment, rehabilitation ka na lang. Na? Ngayon, pag halimbawa, possession of dangerous drugs. Kaso, ang gramo is 5 grams less than 10 grams. Shabu, marijuana, cocaine, opium, yon. So, 5 grams, pero less than 10 grams. Pag marijuana naman 300 grams, less than 500 grams. Ang penalty niyan is ang penalty niya is 12 years, 20 years, 1 day to life imprisonment. Ngayon, pwede kang mag-plea bargaining sa possession of dangerous drugs where the penalty is only 12 years, 1 day to 20. No? So, pwede ka mag-plea bargaining doon. Isa pa, pag halimbawa ang kaso mo is illegal possession of dangerous drug during party, social gathering, at meeting, ang penalty kasi niya life imprisonment. Pwede ka mag-plea bargaining sa possession of dangerous drugs under Section 11B of RA 9165 where the penalty is 12 years, 1 day to 20.
We are VLC. We offer value, providing you with quality review programs and online seminars that bring out the best in you. At VLC, we listen. Adapting to the times, we brought our in-demand on-ground review lectures online with our virtual law companion. Subscribing to this online learning platform means You get 24/7 access to our updated video lectures and bar review notes from the best and most respected lecturers and professors. At VLC, we collaborate, working with the best technology providers through our learning management system to best prepare you for the first ever digitalized bar exams. We work hand in hand with legal experts you can trust, providing top-notch services to those who need it the most through our free online legal consultations and free lecture series. Value, listen, and collaborate. This is the VLC way, and we are VLC.
Only a judge may issue search warrant or warrant of arrest, nobody else. That is very important. And before a judge may issue search warrant or warrant of arrest, what are the requirements? First, there may be probable cause. Number 2, to be determined personally by the judge. Number 3, after examination under oath of the complainant and the witnesses may produce. Number 4, particularly describing the place to be searched and the persons or things to be seized or arrested. Those are the requisites before a judge may issue a search warrant or warrant of arrest. But first of all, take note, only a judge may issue a search warrant or warrant of arrest, nobody else. That's why it's still pending at the Supreme Court now, di ba?
Article 3, Paragraph 3 of the Family Code, we have the provision for a marriage ceremony. Now, in our jurisdiction, we do not recognize unceremonial marriages. There must be a marriage ceremony. The minimum requirement is that the contracting parties must personally appear before the solemnizing officer and personally declare that they take each other as husband and wife in the presence of at least 2 witnesses of legal age. Now, even assuming that there was no witness here, the marriage will also remain valid. That will be considered a mere irregularity that will not affect the validity of the marriage. Now, under Article 26, Paragraph 1 of the Family Code, all marriages solemnized.
Felony within the contemplation of Article 4 of the Revised Penal Code. As a general rule, threat to spank, that is a felony. Tinakot mo sasaktan papaluin Pero in this case, the threat to spank is a justified threat to spank due to the circumstance of defense of property. And second, the threat to spank was made in the exercise of a right under the self-help doctrine, Article 429 of the Revised Penal Code. Owner or lawful possessor of a thing has the right to exclude others from the enjoyment or disposal thereof, and for this purpose he may use force which is reasonably necessary to prevent or repel an act.
Is not allowed to do if you talk about issuance of a warrant of arrest is to follow blindly the finding of probable cause by the prosecutor, precisely because the prosecutor determines probable cause for the filing of the information in court, whereas the judge determines probable cause for the issuance of warrant of arrest. So okay na yan. Pero sa issuance ng search warrant, as mentioned, it should be probing. In other words, my friends, the judge must personally conduct an examination of the complainant and the witnesses that he may produce under oath or affirmation. The examination by the judge must be probing. Okay? It is not enough to merely adopt the questions and answers asked by the previous investigator during the PI. Magkaiba yun. Bakit? Kailangan po the judge should personally examine the complainant and the witnesses. So these are the
are VLC. We offer value, providing you with quality review programs and online seminars that bring out the best in you. At VLC, we listen. Adapting to the times, we brought our in-demand on-ground review lectures online with our virtual law companion. Subscribing to this online learning platform means you get 24/7 access to our updated video lectures and bar review notes from the best and most respected lecturers and professors. At VLC, we collaborate, working with the best technology providers through our learning management system to best prepare you for the first ever digitalized bar exams. We work hand in hand with legal experts you can trust, providing top-notch services to those who need it the most through our free online legal consultations and free lecture series. Value, listen, and collaborate. This is the VLC way. And we are VLC.
Only a judge may issue a search warrant or warrant of arrest, nobody else. That is very important. And before a judge may issue a search warrant or warrant of arrest, what are the requirements? First, there may be probable cause. Number 2, to be determined personally by the judge. Number 3, after examination under oath of the complainant and the witnesses may produce. Number 4, particularly describing the place to be searched and the persons or things to be seized or arrested. Those are the requisites before a judge may issue a search warrant or warrant of arrest. But first of all, take note, only a judge may issue a search warrant or warrant of arrest, nobody else. That's why it's still pending at the Supreme Court now, di ba?
Article 3, Paragraph 3 of the Family Code, we have the provision for a marriage ceremony. Now, in our jurisdiction, we do not recognize ceremonial marriages. There must be a marriage ceremony. The minimum requirement is that the contracting parties must personally appear before the solemnizing officer and personally declare that they take each other as husband and wife in the presence of at least 2 witnesses of legal age. Now, even assuming that there was no witness here, the marriage will also remain valid. That will be considered a mere irregularity that will not affect the validity of the marriage. Now, under Article 26, Paragraph 1 of the Family Code, all marriages solemnized.
Felony within the contemplation of Article 4 of the Revised Penal Code. As a general rule, threat to spank, that is threat, that is a felony. Tinakot mo sasaktan papaluin Pero in this case, the threat to spank is a justified threat to spank due to the circumstance of defense of property. And second, the threat to spank was made in the exercise of a right under the self-help doctrine, Article 429 of the Revised Penal Code. Owner or lawful possessor of a thing has the right to exclude others from the enjoyment or disposal thereof, and for this purpose he may use force which is reasonably necessary to prevent or repel an act.
Is not allowed to do if you talk about issuance of a warrant of arrest, is to follow blindly the finding of probable cause by the prosecutor, precisely because the prosecutor determines probable cause for the filing of the information in court, whereas the judge determines probable cause for the issuance of warrant of arrest. So magkaiba yun. Pero sa issuance ng search warrant, as mentioned, it should be probing. In other words, my friends, the judge must personally conduct an examination of the complainant and the witnesses that he may produce under oath or affirmation. The examination by the judge must be probing. Okay? It is not enough to merely adopt the questions and answers asked by the previous investigator during the PI. Magkaiba yun. Bakit? Kailangan po the judge should personally examine the complainant and the witnesses. So these are the